Okay, I need you to stay with me here because what I'm about to walk you through is genuinely unprecedented in American history. And I don't use that word lightly. I've said it before about things that turned out to be significant but manageable. This is different. At 6:47 this morning Eastern Time, a courier departed the Supreme Court building carrying two sealed envelopes. One was addressed to the Director of the United States Marshal Service. The other was addressed to the Director of the United States Secret Service. Inside those envelopes was identical documentation, an emergency order from the Supreme Court of the United States establishing a 72-hour arrest compliance deadline for Donald J. Trump. If you're just joining us right now, hit subscribe to Helen Northman immediately. This is not speculation. This is not clickbait. This is constitutional machinery activating in real time, and you need to understand exactly what's happening. The Supreme Court order, which legal observers are calling the most extraordinary judicial directive in modern American history, contains language that has never been used against a former president. The document, portions of which have been leaked to multiple news organizations, states that Donald Trump has willfully and repeatedly defied 4 separate orders from the nation's highest court over a 6-month period. The charges are criminal contempt of the Supreme Court, and the deadline for voluntary surrender is Friday at 5 p.m. Eastern Time. That's 72 hours from now. After that deadline passes, the United States Marshal Service is authorized, and I want you to hear this word clearly, authorized to execute forcible arrest. What that means in practice is something this country has never witnessed. Federal marshals entering the residence of a former president, potentially against resistance, to take him into custody by force. Here's what makes this constitutionally catastrophic. Donald Trump is protected by the United States Secret Service. That protection is mandatory, lifetime, and not subject to the preferences of the former president, which means right now, at this moment, 2 federal law enforcement agencies are operating under directly conflicting orders. The Secret Service is sworn to protect Donald Trump from all threats to his person. The U.S. Marshal Service has just been ordered by the Supreme Court to arrest Donald Trump and take him into federal custody. Those 2 directives cannot coexist. If Trump refuses to surrender voluntarily, and every indication suggests he will refuse, then Friday at 5:01 p.m., armed federal agents will face each other outside Mar-a-Lago with fundamentally incompatible missions. One agency protecting, one agency arresting, both believing they are following lawful orders. The order itself is 89 pages long. It was signed by 7 justices. Only Clarence Thomas and Samuel Alito dissented. Chief Justice John Roberts personally authored the majority opinion, and sources who have read the full document describe the language as unusually harsh, almost angry. Roberts wrote, and I'm reading directly from the leaked excerpts, that Trump's defiance represents a clear and present danger to the constitutional order, and that no individual, regardless of former office or current influence, can be permitted to nullify the authority of this court through willful noncompliance. That phrase, clear and present danger, is not judicial rhetoric. It's a legal conclusion with enormous weight. It's the same standard used to justify restrictions on speech during wartime. The Chief Justice of the United States has formally declared that a former president's behavior poses the kind of threat to the republic that justifies emergency action. What did Trump actually do to trigger this? The 4 violations cited in the order span 6 months. The first involved defying a subpoena for classified documents. The second involved public statements attacking witnesses in an ongoing federal case, statements the court had explicitly prohibited. The third involved coordination with co-defendants despite court-ordered restrictions on contact. And the fourth, the one that apparently pushed the court beyond tolerance, involved Trump publicly stating on Truth Social that he would not comply with any Supreme Court order he deemed politically motivated. That last statement, made 3 weeks ago, was apparently what convinced Chief Justice Roberts that voluntary compliance was impossible and that the court had to act decisively or surrender its authority entirely. Now, here's what happened in the hours after that order was transmitted. At 7:15 a.m., Secret Service Director Kimberly Cheadle received her copy. At 8 a.m., she convened an emergency video conference with the Attorney General, the Director of the FBI, and the head of the U.S. Marshals Service. That meeting lasted 2 hours and 40 minutes. Participants described it as the most tense interagency discussion in recent memory. At 11:34 a.m., Donald Trump posted on Truth Social. The post read, "Corrupt Supreme Court attempting coup will never surrender to illegitimate order. Second Amendment patriots know what to do." That post has been viewed 14 million times. It has been shared 680,000 times, and law enforcement agencies across the country are treating it as a credible call for armed resistance. We are 72 hours from a deadline that one side has vowed not to meet and the other side is authorized to enforce by any means necessary. All right, before we go any further, we need to establish exactly what criminal contempt of the Supreme Court actually means and why this has never happened before. Most people, when they think about contempt of court, think about someone yelling at a judge or refusing to testify. That's contempt, but it's usually handled at the trial court level with fines or brief jail sentences. What we're dealing with here is something entirely different. This is the Supreme Court of the United States, the final arbiter of constitutional law, formally declaring that a former president has engaged in conduct so defiant, so threatening to judicial authority, that criminal prosecution is required. In 247 years of American history, this has happened exactly 3 times to any individual, and never to a president or former president. The first case was in 1807 when Aaron Burr was held in contempt during his treason trial, though he ultimately complied before arrest became necessary. The second was in 1934 when mining company executives refused to produce documents in an antitrust case. They were arrested, jailed for 30 days, and the precedent established that Supreme Court orders are not suggestions. The third case occurred in 1974 during Watergate when several Nixon administration officials faced contempt charges for destroying evidence. Richard Nixon himself came within days of facing a similar order, but he resigned before the Supreme Court had to act. That resignation, that choice to step down rather than defy the court, is what prevented the constitutional crisis we're now facing. Here's what makes Trump's situation legally unprecedented. Each of the 4 violations cited in the Supreme Court order constitutes a separate criminal count. Criminal contempt of the Supreme Court carries a maximum sentence of 6 months in federal prison per violation. Trump is facing 4 counts, which means he's looking at up to 24 months of incarceration if convicted on all charges. But here's the critical detail that most legal analysts are missing. This is not a charge that can be pardoned by a future president. Presidential pardon power extends only to federal crimes prosecuted by the executive branch. Contempt of court is a power reserved to the judicial branch. The separation of powers doctrine means that a president cannot pardon someone for contempt of the Supreme Court because that would allow the executive branch to nullify judicial authority. If Trump is convicted, no future president, not even Trump himself, if he were to win in 2024, could erase that conviction. It's permanent, it's on the record, and it carries mandatory consequences, including potential disqualification from holding federal office under certain interpretations of the Constitution's insurrection clause. The Supreme Court order also includes procedural details that reveal just how seriously the justices are taking this. The order specifies that if Trump surrenders voluntarily by the Friday deadline, he will be transported to the federal courthouse in Miami, where he will appear before a magistrate judge for initial proceedings. He will be booked, fingerprinted, and photographed, the full arrest process that applies to any criminal defendant. However, the order also indicates that given his status as a former president, bail would likely be granted immediately with conditions. Those conditions would almost certainly include surrender of his passport, restrictions on travel, and prohibition on any public statements about witnesses, jurors, or the judicial process itself. That last condition is what legal experts believe Trump will find impossible to accept. His entire legal and political strategy has been built on attacking the legitimacy of the courts, the prosecutors, and the process. Being ordered by a federal judge to remain silent about those attacks would, from his perspective, be tantamount to admitting guilt. But the order also contains a second path, and this is the one that has law enforcement preparing for potential crisis. If Trump does not surrender voluntarily by 5 p.m. Friday, the U.S. Marshals Service is authorized to execute an arrest warrant by any lawful means necessary. The language is specific and deliberate. It includes authorization for forcible entry into any location where Trump is believed to be present. It includes coordination with other federal agencies, which legal experts interpret as a reference to potential coordination with or around the Secret Service. And it includes a provision that has never appeared in a Supreme Court order before, authorization for the use of tactical law enforcement resources if standard arrest procedures are met with resistance. That phrase, tactical law enforcement resources, is federal code for specialized units. The FBI's Hostage Rescue Team, the U.S. Marshals Special Operations Group. These are the units deployed in hostage situations, armed standoffs, and high-risk warrant executions. The Supreme Court has effectively authorized a raid on Mar-a-Lago if voluntary surrender does not occur. Smash that subscribe button to Helen Northman right now if you understand how close we are to something this country has never witnessed. And drop a comment below telling me, do you think Trump will actually surrender, or are we about to see a standoff at Mar-a-Lago? Your voice matters in this moment. Let me tell you what's happening right now inside the Secret Service, because this is where the constitutional crisis becomes an operational nightmare. At 7:15 this morning, Director Kimberly Cheadle received that Supreme Court order and immediately understood that her agency was being placed in an impossible position. The Secret Service has one primary mission when it comes to former presidents: protection. That protection is not optional, it's not negotiable, and it's not subject to the preferences of the protectee. It's mandated by federal law passed after the assassination of Robert Kennedy in 1968. Every living former president receives Secret Service protection for life, and that protection extends to defending them against all threats to their physical safety. But here's the problem that has Director Cheadle and her senior leadership in crisis meetings that have been ongoing for the past 12 hours. Is the U.S. Marshal Service executing a lawful arrest warrant a threat? According to the law, no. According to the sworn duty of Secret Service agents who have spent years building personal relationships with Donald Trump, the answer is far more complicated. Sources inside the Secret Service are describing what one agent called open rebellion within the ranks. The Presidential Protective Detail, the specific team assigned to Trump, has been together for years. These agents know his schedule, his habits, his family. They've traveled with him to dozens of countries. They've stood post outside his bedroom. They've taken shifts protecting his grandchildren. And now they're being told that when federal marshals arrive to arrest him, they need to step aside and allow it to happen. Some agents are prepared to do exactly that. They understand that the Supreme Court order is lawful, that their oath is to the Constitution, not to any individual, and that interfering with a federal arrest would make them criminals. But other agents are expressing what sources describe as extreme reluctance to participate in what they view as a political prosecution. Internal messages obtained by reporters show agents texting each other phrases like, "We're not going to be part of this theater and our job is protection, period." One message that has circulated widely among the detail reads, "If they want him, they go through us." That message, if acted upon, would place Secret Service agents in direct confrontation with U.S. Marshals, both sides armed, both sides believing they're following their sworn duties. The legal questions this raises have never been tested in court because this scenario has never occurred. Does the Secret Service have legal authority to prevent the execution of a Supreme Court arrest warrant? The answer, according to every legal scholar consulted, is no, absolutely not. But does the Secret Service have practical capability to prevent such an arrest? The answer is yes, at least temporarily. Mar-a-Lago is a secured facility. It has multiple layers of security, private security contractors in addition to Secret Service, reinforced access points, surveillance systems covering every approach. If the Secret Service detail decides to treat the marshals as a threat and defend the perimeter, there is no scenario where that arrest happens quickly or cleanly. It becomes a standoff, a negotiation, a crisis that could last hours or days. And during that time, every hour that passes with a former president defying the Supreme Court is another hour of constitutional damage that may be impossible to repair. Director Cheadle held a conference call with her entire leadership team at 3 p.m. yesterday. Participants say she made clear that the agency would not interfere with the lawful execution of a Supreme Court order. She reportedly told senior agents that anyone who obstructs federal marshals will face immediate termination and potential criminal charges. But sources also say that several senior members of the Presidential Protective Detail requested transfers immediately after that call. They don't want to be present when the arrest occurs. They don't want to make the choice between their personal loyalty to Trump and their legal obligations to federal law. The requests were denied. Director Cheadle apparently told them that this is exactly the moment when the agency needs experienced professionals who understand the stakes, not junior agents making career-defining decisions under pressure. Those agents remain assigned to Trump's detail, but their presence creates another layer of unpredictability. If they're personally conflicted, if they're emotionally torn, if they're getting pressure from Trump himself to resist, what do they actually do when marshals arrive at the gate? Meanwhile, Trump's response to all of this has been to escalate rather than de-escalate. Since that initial Truth Social post this morning calling on Second Amendment patriots, he has posted 14 additional times. He has called the Supreme Court corrupt, illegitimate, and controlled by deep state operatives. He has claimed that Chief Justice Roberts is compromised by blackmail. He has stated that any attempt to arrest him will be met with massive resistance from millions of Americans who will not stand for tyranny. And at 2:47 p.m., he posted what law enforcement is treating as the most dangerous message yet. The post read, "All patriots converge on Mar-a-Lago. Protect your president from an illegal coup. They want to put me in chains. Show them that America will never surrender to judicial tyranny." Within 90 minutes of that post, reports started coming in from state police agencies across the South. Convoys were forming, caravans of vehicles heading toward Florida, many displaying Trump flags and Second Amendment messaging. Subscribe to Helen Northman right now because what happens in the next 48 hours will be covered here in real time. And I need to know what you're thinking. Drop a comment below. Do you think Trump will actually surrender? or are we about to see a standoff at Mar-a-Lago? Law enforcement agencies across Florida are now operating under crisis protocols that haven't been activated since the immediate aftermath of January 6th. The Florida Highway Patrol reported at 4:15 p.m. that they have identified at least 17 separate convoys moving toward Palm Beach County from Georgia, Alabama, Tennessee, and the Carolinas. These aren't individual vehicles. These are organized caravans, some containing 40 or 50 trucks and SUVs, traveling together with coordination that suggests advanced planning. State police have conducted traffic stops on several of these convoys under routine pretexts, checking for vehicle violations, expired registrations, anything that allows them to assess what they're dealing with. What they found has been reported up through federal law enforcement channels and has resulted in the FBI activating joint terrorism task forces across 3 states. Multiple vehicles were found to contain firearms, which is legal in Florida, but the quantity and type of weapons has raised significant concerns. We're talking AR-15 style rifles, tactical gear, body armor, and in at least 2 cases, law enforcement sources say they observed what appeared to be homemade explosive devices, though those reports remain unconfirmed pending further investigation. Palm Beach County Sheriff's Office held an emergency briefing at 5 p.m. yesterday where Sheriff Rick Bradshaw told his deputies to prepare for what he called a potential mass gathering event with significant risk of violence. The Sheriff's Office has canceled all leave, called in off-duty personnel, and established a joint command center with the FBI, ATF, and Florida Department of Law Enforcement. Hospitals in the Palm Beach area have been placed on alert status. Trauma centers have been asked to ensure they have adequate blood supply and that surgical teams are available on standby. Schools within a 3-mile radius of Mar-a-Lago have sent notices to parents indicating that Friday may be a remote learning day depending on how the security situation develops. This is not speculation. This is not precautionary theater. This is what it looks like when local, state, and federal agencies genuinely believe they may be dealing with mass civil unrest or worse within 48 hours. The U.S. Marshals Service, which will be responsible for executing the arrest if Trump does not surrender voluntarily, has been conducting its own preparations. The agency's Special Operations Group, an elite tactical unit that handles the most high-risk fugitive apprehensions and warrant executions, has been deployed to South Florida. Sources indicate the unit arrived Tuesday night and has been conducting reconnaissance and operational planning from an undisclosed location. The Marshals Service has also coordinated with the FBI's hostage rescue team, which specializes in exactly the kind of scenario that everyone is trying to avoid: a barricaded subject refusing lawful commands with the potential for armed resistance from supporters. The fact that HRT has been briefed and is in position tells you everything about how seriously federal law enforcement is taking Trump's public statements and the movement of his supporters toward Mar-a-Lago. What we're also learning is that there have been behind-the-scenes negotiations happening at the highest levels of government. Sources indicate that intermediaries have reached out to Trump's legal team, offering what's being described as a dignified resolution. The proposal, according to people familiar with the discussions, would involve Trump's attorneys arranging for voluntary surrender at a time and location that minimizes media spectacle. He would be processed quickly, appear before a magistrate judge via secure video link to avoid the courthouse media circus, and be released on bail within hours with conditions that his team would have input on negotiating. The goal is to satisfy the Supreme Court's order while avoiding the imagery of a former president in handcuffs being perp-walked in front of cameras. Trump's response to this proposal, according to sources, was a single word transmitted through his attorneys: never. He reportedly told his legal team that he will not give his enemies the satisfaction of voluntary surrender, that any arrest will have to be forced, and that he believes the images of federal agents dragging him out of Mar-a-Lago will galvanize his supporters and prove to the American people that he is the victim of a corrupt system. This calculation that being arrested by force is actually politically beneficial is what has people inside the government most concerned. It suggests that Trump is not trying to avoid arrest. He's trying to engineer the most confrontational arrest possible. And if that's the strategy, then every effort at de-escalation, every attempt at negotiated surrender, every offer of a dignified resolution is pointless because the outcome Trump wants requires maximum chaos. Legal experts who have dealt with high-profile defendants say this is unlike anything they've encountered. Most defendants, even those proclaiming innocence, want to minimize the trauma and publicity of arrest. They surrender quietly through their attorneys. They avoid the spectacle. Trump appears to be doing the opposite, actively seeking to turn his arrest into a televised event that he believes will serve his political interests. And if he succeeds in mobilizing thousands of supporters to Mar-a-Lago before Friday's deadline, he will have created the exact conditions that make peaceful arrest nearly impossible. Subscribe to Helen Northman right now because the mainstream media won't show you what's really happening. And tell me in the comments, do you think Trump will actually surrender, or are we about to see a standoff at Mar-a-Lago? I'm reading every single comment. The timeline is now clear and unforgiving. We are 47 hours from Friday at 5 p.m. If Donald Trump does not surrender voluntarily by that deadline, the United States Marshals Service will execute an arrest warrant. If Secret Service agents interfere, they will be subject to criminal charges. If supporters create a human barrier around Mar-a-Lago, law enforcement will have to make decisions about how to disperse them. If anyone in that crowd is armed and decides that protecting Trump requires firing on federal agents, we will be in territory that no one wants to contemplate. The Supreme Court has issued its order. Trump has declared he will not comply. 2 federal agencies are preparing for confrontation. Thousands of supporters are converging on South Florida. And somewhere in a secure command center, officials are gaming out scenarios that include words like tactical entry, crisis negotiation, and mass casualty event. This is where we are. This is what 72 hours looks like when constitutional order collides with one man's refusal to accept it. The machinery is in motion, the deadline is set, and what happens when that clock runs out will define whether the United States is still a nation where no one, absolutely no one, is above the law.